It's like, okay, so great. You guys admit that right here. Like, you admit that this came from an agreement. The investigator could not conclude the ballots had been counted twice in the final counts for 2020. Oh no, it was just during the recount, and we didn't include those in the numbers anyway. Democrats tried to sue to force the governor to investigate the Republican election board, right? They don't like the rules that they've made change. Fulton County, the land of Fani Willis, does not want to be monitored in the 2024 election, and they're now suing to stop it. In fact, you can see they filed a verified petition for declaratory and injunctive relief, saying we want the court to say that we're right, they're wrong. We can have our monitors, not their monitors. And they want them to stop with their stop their subpoenas and stop their harassment of Fulton County by issuing an injunction saying stop doing these things. And the big question that we'll have as we read through this is, why doth Fani and Fulton protest too much? Why are they so concerned with having monitors if it was such a safe and secure and free and fair election last time in 2020? Never mind the water main break there in State Farm Arena and all of the other shenanigans that we saw. Never mind all of that. If it was so free and fair, why did Judge Amy Totenberg from Georgia write a huge monster opinion explaining how corrupt the systems were that we read here? If you missed that, that is a must watch. Amy Totenberg, because there are major problems. So after all that happened, they agreed to have some monitors. Now Fulton County is fighting it. So here's what Fulton County, home of Fani Willis, says. You know, in the latest blitz of last-minute attempts to drastically impact the election, with early voting is starting in just a few days, and the election is on the 5th a few days from there, the state election board, those amazing people that we saw yesterday that have been very, very accommodating to Fulton County, have demanded that the Fulton County BRE capitulate to the appointment of multiple election, they call them monitors, right? We don't want your monitors that have been handpicked by you people for the upcoming election, saying the state election board has no statutory authority to force us to accept this and to force Fulton County to pay for election monitors that were picked by them. They don't have any statutory authority. Now, the allegations giving rise to the current demand for additional election monitors for the election involve 2020 election violations that they say have already been investigated multiple times. And Brad Raffensperger, the Secretary of State, and the review board have already looked into this. And so we don't need monitors for 2024 because you're complaining about 2020, and in the 2020 election, we've already investigated that. Now, more recently, Fani and her Fulton people say more recently, following another investigation of 2020 by Raffensperger, the state election board agreed to resolve the issue by issuing a letter of reprimand to Fulton, the appointment of independent monitors agreeable to Fulton, the secretary, and the board, right? That's that private agreement they all agreed to. It's like, okay, so great. You guys admit that right here. Like, you admit that this came from an agreement. So why are you spending all this time in paragraph 2 talking about the statutory authority? It's a red herring because they're not referencing that statutory authority. They're not just pulling this out of their booties and saying, hey, we've decided to investigate or to unilaterally appoint monitors to you. It's not what they're saying. The state election board issued its letter of reprimand back in June of this year. Then Fulton, the secretary, and Fulton, which must pay for the monitoring, have all agreed to an independent monitoring proposal. But the state election board has refused to agree to that proposal. Moreover, the state election board has not even presented them with a memorandum of understanding that sets forth the terms acceptable. Instead, members of the board have insisted that they pay for a slate of additional monitors handpicked by them. And by the way, it would be handpicked, they say all the time, bipartisan board. Apparently is made up of 3 people who have authorized subpoenas against Fulton County. And as we saw yesterday from the board members, they're irritated with Fulton County. The memorandum of understanding, they said they voted on the subpoena because they're so tired of trying to get your understanding there in Fulton. They've already made multiple list requests and been accommodating all the way since June. It's now October. You haven't given them the documents that they've demanded. Now, even more troubling, says the Fulton people, the Board of Elections have stated in meetings that the election board would disavow Fulton County if they did not accept the monitors proposed by them. And they want their own monitors to come in. And the board says your monitors have a conflict of interest, just like Nathan Wade and Fani did. And nobody cares. The state board and their latest actions directly conflict with the statutory authority granted to it. Okay, then why did you guys agree to it? The action requests declaratory and injunctive relief. They say, all right, now we seek a declaration that the board lacks authority to force us to accept and pay for the monitors that were handpicked by them. And in connection with this request for declaratory relief, they also seek an injunction to stop them from taking any formal action to force them to accept our monitors. They do not want to be monitored by their board. Petitioner intends to seek immediate relief if they take any action against us. And so the subpoena came after this lawsuit was filed. So the parties, we know, Fulton County State Board and the defendant, state of Georgia, can be served through Brian Kemp. Now, they say in Georgia, each county has an elections superintendent, and Fulton County, in the county, they assigned management responsibility to the Fulton County DRE. Now, the state board has statutory limited enforcement powers that do not include forcing them to use monitors. They say that the law doesn't give them the power to force them to do it. And it's coming at this, it's like, well, then why did you agree to do it, right? You should have raised that objection before you entered into a settlement agreement where you said, we'll appoint monitors. No provision of this authorizes them to appoint monitors or to force us to do it. But you agreed to do it as part of terms of the settlement. Now, after they appointed a performance review board in 2021, the review board recommended taking action over the board, which they accepted. Now, when the alleged violations that were investigated talked about double scanning. Now, as this report explained, multiple additional protective measures have been added to ensure that the double scanning of ballots that occurred in 2020 is not something that happens again. Wow, that's interesting. I thought they said that nothing like that happened because it was the most safe and secure election of our entire lives and in the entire universe. Now, the performance review addressed numerous other allegations, and it did not recommend the removal of the Fulton County Board. Now, it emphasized that they were engaged in driving improvements, and so we can keep the board. They're not that bad. And so the state election board approved the performance review. So, like, we may have had problems, but we fixed them, and you guys approved our fixed problems. Then, after another complaint that was resolved, we agreed to monitors. In July 2022, two voters filed a complaint with the board against Fulton County and Fulton County, two boards, BRE and DRE, about election violations. In May, the Secretary of State investigator reported the results of the investigation, finding that Fulton County double scanned a small number of ballots during 2020 recount, but otherwise rejected virtually all of the other allegations. So, okay, there you go. They did double scan some ballots in Georgia. Great. Despite finding double scanning of a small number of ballots, the investigator could not conclude the ballots had been counted twice in the final counts for 2020. Oh no, it was just during the recount, and we didn't include those in the numbers anyway. So it was small, but not small enough that they mention it, right? If it was like less than 100, they probably would have mentioned it. What is the number? Now, the Secretary of State investigator also noted, even if these votes had been counted twice, the outcome would not have changed. Okay. Yeah, but you can't admit that you did double count that one bucket of votes and say that there was a problem with that one bucket, because then we start asking, well, what other buckets have you not investigated or looked into yet? Now, 4 state board election members attended the presentation. They were there. Now, following the presentation, the board members offered several motions to fix some of this. None of those motions got a second. Finally, Mr. Lindsay made a motion for a letter of reprimand. And then, check it, the state election board, the secretary, and Fulton County reached a mutual agreement. There you go, it's a contract for Fulton County to retain an independent monitor to observe Fulton County in November 24. Boom, they agreed to it. Now, the motion included a stipulation that the parties agree to a monitor by the next hearing in July. In the event the parties could not agree on a monitor, Mr. Lindsay stated he'd come back with a motion to send it to the AG. They seconded the motion, voted 2-1. Johnson voted against, and the other person did not vote. Then in late May, Janelle King assumed Lindsay's seat, and she was fired up yesterday, as we saw. Then they did issue a letter of reprimand, finding that Fulton County violated the election board rules about the double scanning of ballots. Oops. Then it directed the Secretary of State and others to enter into a memorandum of understanding about an election monitor. Then the Secretary of State accepted a monitor proposal by Ryan Germany, the former lawyer for the Secretary of State. Secretary of State's like, yeah, you can use my guy to do this. And they say, wait, what? That's not an independent monitor in any way. Fulton County Board got 2 proposals, one from Ryan Germany, one forwarded from SEB member Janice Johnson. After considering the 2 proposals, the board accepted Germany's proposal and rejected Johnson's. Now, at the end of the board term, then they appointed this person in Fulton County. Then Germany, the other guy who used to work for the Secretary of State, presented his proposal to the board. The state election board met again in August. During the meeting, they talked about 10 additional monitors, adding them to Germany's team. After the meeting with the chair, Fulton County asked them if they could make its proposal at another meeting. The state board, though, did not make an appearance on August 29th. Then at August 29th in Fulton, they voted to reaffirm Germany. The Fulton County Board approved the agreement to have Germany's election team serve as monitors. Then the State Board of Election met September 20th, and they expressed frustration that they were implementing Germany's plan. The board directed the chair to arrange another meeting, and they discussed several issues. Then in October, State Board Johnson member sent Allen an email to add an agenda item, saying that they wanted to add 6 of whom people to the list. At no time has the state election board presented an executable contract. Now the conduct as required, and so we seek declaratory relief by ordering them to use certain monitors in the election and let us use Ryan Germany. All right, so here are the counts. They want a request for declaratory judgment. They say there is a controversy here. Their attempt to force us to use certain hand-picked monitors who've already been rejected by us will cause us harm. And so basically it's a contract dispute essentially. We agreed to have monitors, but we want to use our monitors. And the board says, well, those are crap monitors, so you can't use those. It's not agreeable to us. And so they seek declaration, the court declaring that they're right, state's wrong, and stopping them from interfering with their monitors in any way. Signed by Michael Tyler. And it's a fun one because it begs the question, why, oh why, is Fulton County so opposed to having the state have some additional monitors there? Why do they want this Ryan Germany fellow and people who are already deeply embedded or formerly embedded with the state government to come in and act as independent monitors? He was general counsel for the Secretary of State. It's not independent at all. He's just like retired and now is going to be monitoring the elections. So interesting. Now, similarly, you may have also seen this. They were trying to investigate the Georgia election board and they sued to basically remove them. And this Judge Glanville, you remember him from the totally disastrous YSL trial, he came out and he dismissed a lawsuit on Wednesday. So Democrats tried to sue to force the governor to investigate the Republican election board, right? They don't like the rules that they've made change. The Democrats can't compel the governor to start ethics hearings, which could lead to removal from office based on letters that they called formal charges. The judge says those are not formal charges, so those are not coming in. But it's very typical for the Democrats. If they don't like your politics, if they don't like you investigating their shenanigans, well, they just come after you and your family and take you out like mobsters.